Hello everyone, I am Assistant Professor Ramdas Sonnar, Shri Omkarnath Malpani Law College Sangamner. I am introducing today's topic, historical background of the company law in India. What is the company law? Company law established in the year firstly 1844 in India. That time in India, company law is a very optional subject, but today's time company is very important subject. Firstly, company law began with the Company Act 1850 modeled on British Company Act 1844. This is a start in India company, and then after second time company law came into force in India 1882. 1882 repealed all the previous laws and remained in force till 1912 through amended many times. And Indian Company Act 1930 was based on British Company Act. The 1913 Company Act is very important in our India, because that time Company Act is very important, and some new provision added, means directors of the company and types of the company, various types of the company first arrived in the 1930, and other provisions means shares related new provisions added in the 1930. That reason this act is very important firstly in India 1930, and before some act established, but this is only optional act, but firstly important 1930 act is important. Then after various amendment in the company, the first 1940 first amendment, 1915, 1920, 1926, 1930, 1932 and 1936, many of the amendments relevant to the company law provisions. And then after one act amended in 1936 was based on the lines of the British Company Act 1929 and became operative from 15th January 1937. This is a history of the pre-independence in India. But then after independence India, only two act company related established. First act 1956, Companies Act 1956. This act is related to the other some new provision added, means new provisions, memorandum of association, article of association and other provisions added in this act. After the independence, it was found that the existence Company Act should be amended to suit the changed condition in the country. The central government appointed as 12 members, means in the 1956 Company Act historical background, firstly 12 members committee appointed, and 12 members chairperson Mr. C.H. Bhabha, known as the Bhabha Committee, and submitted their report in April 1952. This is an important committee, and all members, very brilliant members, expert members and knowledgeable members. The central government brought a bill in parliament on 2nd September 1953. The parliament appointed a joint parliamentary committee in May 1954 to go into the recommendation of the Bhabha Committee and to suggest any modification or changes on the basis of the joint parliamentary committee. The parliament passed the new act in November 1955. That time former Prime Minister Pandit Jawaharlal Nehru and other members received the President assets on 18th January 1956. This act came into force with effect on April 1956. It consists of total number of section, that time 658 sections and 14 schedules. This is the history of the 1956 Company Act after independence. And then after in 1956, then after various amendment related to the company, some new commercial activities included this amendment. in amendment in the year 1956, 1968, 1982, 1996 and various amendment declared by the government. And next point related to the history of Company Act 2013. This is a new era and today's situations act established in our government. Firstly, Company Bill 2008 introduced in Lok Sabha on 23 October for the first time to replace 52 years old Company Act, means 1956. Then after firstly 2030 Act passed and then time it lapsed due to dissolution of Parliament. 2008 bill modified and reintroduced on 3rd August 2009. A bill referred to Standing Committee for Review report tabled in Lok Sabha on 13th August 2010, introduced in Lok Sabha on 14th December 2011. Company Bill passed in Lok Sabha on 18th December 2012. Enacted as Company Act 2013 with President assent on 29th August 2013. Company Bill passed in Rajya Sabha on 8th August 2013 on receiving the assent of August 13, 2013 as the Company Act 2013. Company Act 2013 has been divided into 29 chapters and contains 417 sections and 7 schedules. The Company Act 2013 aims to improve corporate governing, simplify regulation, strengthening the interest of minority investors. Means Company Act total today's time Company Act 470 section applicable and 29 chapters and 7 schedule and aim of this act, the today's new situation and globalization, privatization and other things change all old and India commercialization increase day by day and industrialization increase, urbanization increase. That reason company need to every citizen of India and this is the main aim to establish the company in India. Definition of company. What is the definition of company? Company particular one definition, section 2 clause 20. Company means forms and registered the previous act and current act, means before act 1956, 2013 act related some ideas related to the company. This is a definition of the company. Company is a corporate body and legal person having status and personality distinct and separate from the member constituting it, means company. Company means a corporate body and two or more person come together and establish one company and all members company related members one purpose, benefit only, get a benefit only, not loss. Company is a legal person, means company is a artificial person and legal person recognized by the law. Company is a one name, company is a separate person, company is a different and members is a different. Member cannot interfere to company, only members follow the rules and regulation. And status and personality distinct and separate from the members constituting it. Section 2 clause 20 of the Company Act 2013 defines company means a company formed and registered under this act or an existing company. This is the definition of the company. Meaning of company. As per the Justice Lindley, company means an association of person, group of person who contribute money or money's worth, means money or money related wealth, means money's worth to a common trade or business. The common stock to contribute it or to form it belong are members. The proportion of capital to which each member is entitled is his share. Shares are always transferable. Company's shares is always transferable to another company. Them is often more or less restricted, means shares only private company, some exception restriction, but generally shares is not restricted, means always company shares transferable, public company shares always transferable. Characteristics of company. What is the characteristics of company? 9-10 characteristics is very important related to the company. A company is a voluntary association of person registered with the register of companies, and the following characteristics. Company related following characteristics. First characteristic, separate legal entity. Company is a separate and member is a separate, director is a separate. Company and director is not one person. One case law related, following case law, Salmon versus Salmon and company. As a result, company can enter into a contract by property in its one name. Company's property totally one name, not any members or not any directors purchase the property to company or transfer the property to another place. This is not allowed. That reason, property in its one name. And another thing, lend money, means company lend money to another person. Open bank account own name, means company ownership bank account related, or file a suit in a court of law. Any court, company go to court, but not any members or directors personal suit. The company file a suit in a court against a third party. Likewise, others can also file a suit against the company, means another person file a suit against the company. Company can do all such acts which a natural person would do in the course of his business. One case law, Solomon versus Solomon and company. This is a important case law related to the separate legal entity. Solomon established one company. This company's name is Solomon versus Solomon, and invest the money in the company, and purchase and Salman's wife, daughter and his 4 sons, all shareholders were holding in 1 share each, and rest all shares were held by Solomon. He sold his business to the company for pound 38,782, and the company had issued share in favor of Solomon and as a purchase consideration. The purchase consideration was shares pound 20,000, debentures pound 10,000, and balance paid in cash. Solomon was the MD, means managing director, and 2 of his sons were other directors of the company. After 1 year, the company ran into financial difficulty, and the debenture holders appointed a receiver, and the company went into liquidation. The assets of the company were not even sufficient to discharge the secured debentures which were held by the Solomon, and nothing was left for unsecured creditors. Claimed that the company was a mere agent for Solomon, and they were entitled to the payment of their unsecured debt in priority to debentures holder. They also pleaded that Solomon as a primary beneficiary was ultimate responsible for all the debts. This is a most important case law, Solomon versus Solomon company. This case law related to the company is a different and members is a different. Solomon is a members and directors in the company, and this person is totally different, not company. And other creditors, one claim to court, creditor go to court and one claim. Solomon is a company, Solomon is a company's person, but not. Solomon is a different person, and Solomon's only investment in company, and Solomon's Solomon related person means wife, 4 daughter and son in the members in the company, but company is different. Court judgment, the House of Lords held that the said company comes into existence after its registration under the existing law the company has been validly constituted as per the requirement of the existing law, like 7 members were required to from a company. The court say that 7 member is a different and company is a different, and in public company and minimum member 7 criteria or condition, any public company 7 members is necessary. That reason court say that 7 members were required, and Salman and 4 son and 1 daughter and wife, total number of 7 total including this company. Therefore, the company has its one existence. Company is a separate existence, or personality is separate and distinct from its members, and as a result shareholders cannot be held liable for the acts of a company. This is a judgment of the court. Next features, next characteristics of company: perpetual succession. Perpetual means permanent company, permanent establishment of company. Only exception to the law or national company law tribunal, means NCLT or national company law appellate tribunal, decided by the company winding off. Other person no company winding off, or no any person close to the company. This is a second exception, second characteristics of the company. In company law, perpetual succession is the continuation of a company, corporations or existence despite the death, retirement, means any company related directors, employee death or retirement or insolvency, insanity, minority, company no problem, company is always start, always working, commencement of the business. Change in membership or exist from the business of any owner or member, or any transfer of stock, company is always continue starting. It implies that a company will continue to exist until and unless it is the forced by the law to wind up. Only exception to the law, forced by the law to wind up, this is the exception only. Another thing, company no matter people come to go, any person member and then after some go to another company and not the member, no effect of the company. Company will remain in existence because it has separate legal entity and perpetual succession. A company is a juristic person and its life does not depend on the life of its members. Okay. Common seal. What is the common seal? Common seal in Marathi language Rabri Sikka, but today's 2015's one amendment say that common seal is a only optional, not compulsory, not binding. Common company is not a real person, the how the document will be signed, the common seal that time important. Company use common seal. Since company has no limbs or mind like human being, therefore a common seal is required to authenticate the documents executed for and on behalf of company. Common seal is the official signature of a company, that reason common seal is important. The common seal should be kept in the safe custody of a responsible official, and such official should be authorized by the board of directors. As per the Company Amendment Act 2015, the requirement of having a common seal has been made optional. In case a company does not maintain a common seal, the document shall be issued and executed by any two directors. Means no any company common seal in 2015 amendment, but two directors signature any document is necessary, important. And the company secretary of the company, if any document does not bear common seal of the company, is not authenticate and such document has no legal force. Means two directors no signature and no common seal, this document is not authenticate, this document is not legal. The name of the company must be engraved on its common seal, a rubber stamp does not serve the purpose. Next features, next characteristics, transfer of shares. Transfer of shares, any person, means one person can easily buy and sell these shares, and transfer can take place easily. Means one company to another company, any members shares to transfer. The shares movable property of company are freely transferable in the manner provided in the article of the company. Means movable related any shares movable means any goods transfer to one place to another place. For example, gross, this is a gross or any goods transfer to another place. but immovable goods means not transferable goods, some restriction share transferable restriction. Article of the company. However, in case of private company there are certain restriction but not prohibition on transfer of share. Only private company some restriction but another company not any restriction. Another means public company, foreign company, government company, and another various company, holding company, subsidiary company, banking company, any another company. Next characteristic, contractual rights. What is the contractual rights? Contractual rights means our Indian Contract Act 1872, right to the citizen of India, according to the Contract Act, various principles of the contract, various sections of the contract, contract one company to another country, company. This is the rights of the company, rights of the company related activity. Firstly, contractual rights. A company being a legal entity different from its member can enter into contract for the conduct of the business in its own name. Any company contract to another company own name. Next characteristics, limitation of action. Limitation of action means a company cannot go beyond the powers. Company some restriction, established time company, one document declared, one document established, this document name of the memorandum of association, and this document 5 content is very important: name clause, article name clause, alteration clause, capital clause, liability clause. This is clause is important, and not this clause violation means not beyond the powers of its charter, not beyond the powers of its memorandum of association. That reason company some limitation. The memorandum of association, the action and object of the company are limited within the scope of its memorandum of association. Next characteristic, voluntary association for profit means all person established one company willing, desire, no any coercion, no any undue influence, no any fraud or no any misrepresentation, means freely minded, freely established company, registered ROC means registered of the company office, and no any burden, no any compulsion. A company is a voluntary association for profit. It is formed for the accomplishment of some public goals, and whatsoever profit is gained is divided among its shareholders. Next features, separate ownership and management. Company's ownership is a separate, means company is a owner, not any members. The members of company do not participate in the day to day affairs of the company. Company regular work, not members participate, not directors participate, only participate in the meeting, other thing no participate. The company is managed by elective representative of the shareholders, known as board of directors. The directors are appointed as well as removed by the shareholders. Okay, thank you.